next case to come before the court is City of North Ridgeville v. Sharon, Zilka et al. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know, or I'll be keeping track of the time. I'll try to let you know when you're wandering into that rebuttal time, should that occur. The arguments are being recorded, so please stay behind the podium, keep your voices up, introduce yourselves. You should not use the names of children or victims or minors, should that be relevant to your argument. You can refer to those folks by initials. We have read your briefs and we're ready to proceed when you are. And counsel, I would just ask you, would you like to reserve time for rebuttal?
Yes, approximately 2 minutes.
Okay, then you may proceed when you're ready.
Okay, thank you, Your Honors. My name is Brian Moriarty, and I'm the Law Director for the City of North Ridgeville. As indicated, I'm sure you guys have read the briefs already and are familiar with the facts. I think the highlights are mainly that we have filed this petition to appropriate property for a roadway project. It's a roundabout between the City of Avon and North Ridgeville at an intersection that had been causing some problems. The initial filing did not contain the proper resolution attached to it. There was a motion to dismiss that was filed because of that.
It didn't contain it, or there wasn't a resolution at the time?
Well, we had a resolution, but the resolution was kind of for the project and the overall project, but it wasn't specifically for the need to appropriate the property. So we attached a resolution, but it didn't encompass what the statute required.
So at the time of filing the complaint, there was no resolution necessity?
I'm sorry, what was that?
At the time of filing the complaint, then, there was no resolution of necessity that was passed by the City of North Ridgeville?
Correct, correct. So we sought leave from court to amend the complaint. We amended it, we went and obtained the resolution per the statute, attached it, and refiled it. Shortly thereafter, another motion to dismiss was filed saying that the court never had jurisdiction in the first place because the initial filing lacked that resolution. Now, we don't agree with that. We didn't think that that argument really had any merit.
Counsel, was that motion just for dismissal, or was it for attorney's fees as well?
I think there's two motions, one for a motion, and you could probably clear it up. It was either a motion to dismiss and then a motion for attorney's fees, or maybe it was a combined motion.
Well, filed at the same time.
I believe so, yeah. Nevertheless, we indicated to counsel because we saw that where this was going, we thought that there was probably going to be an interlocutory appeal that might be filed and further court delays. So for that reason, we indicated to the parties that we were going to go ahead and refile it, or dismiss it and then refile it, seeking the same property with the same amount of money, because there had been also a Columbia gas line project that had been going on, and that was being delayed as well. So once the project was delayed, we went ahead and refiled it, deposited the exact same money. It was under the quick take provisions provided for in the statute. We went ahead approximately a month later. We started removing trees. The project is underway still. It's been a very long project. We haven't been able to finish it yet. But the court, after we had taken the trees down, ruled on the motion for attorney's fees. In our arguments, the two assignments of error that we raise are: one, subject matter jurisdiction for the court to rule on that. It's not clear to me whether the ruling was based upon the initial attorney's fees motion that was filed, or the one that was filed after we had voluntarily dismissed the case. Nevertheless, I believe that by voluntarily dismissing it and then having the court close the case and making it final, that would preclude any type of attorney's fees motion filed afterwards. And we believe that it precludes the court from considering any further motions that were pending at the time of the dismissal.
Let me ask you a question to see if I understand your argument. Here, you did go on with the project.
Correct.
And you did, take the property,
Correct.
and everything. But let's say that you had dismissed your complaint and decided you weren't going to do the project anymore. Okay. Are you saying then that the original defendant, the property owner, would have to file suit to get the
No, I think what would happen there is two things. One, if we didn't intend to refile, or if we weren't gonna refile it, I think that the party, like the Sellers case that was relied upon by the court, files a motion to vacate that, the court's order dismissing the case, to open up that issue of attorney's fees again. That's what happened there, and I think that's kind of instructive for the trial court as to how the procedure should go. And
So even though the defendant raised the issue and filed for attorney fees, you're saying he would still have the burden of filing a motion to vacate?
Well, I don't think it's a burden. I think that he filed the motion, and at the time that the court dismissed the case, the court didn't rule on it. So if it wants to proceed going forward with the attorney's fees motion, then they would have to, go ahead and either one, vacate. I would think either file a motion to vacate or ask the court to reconsider it in some manner. Again, in our argument, we raised that the general rule is that once the case is voluntarily dismissed and the court accepts that and closes the case, it loses jurisdiction on any further proceedings regarding that. The exception to the rule are sanctions or frivolous filings. That's a lot of case law that was in there. Those all relate to collateral proceedings, and that's not the case in this instance. This is mainly pursuant to statute 163.21. The second assignment of error that we raised is mainly whether the court erred and or abused its discretion in its interpretation and application of 163.21A. When we were going through all the case law, we did notice that, and I think we brought it up in our briefs, that the rule from the Ohio Supreme Court is any kind of interpretation, I'm sure you guys are aware, is de novo review. There is a case, however, I think out of this county that dealt with whether or not there was an abandonment of proceedings, and that was an abuse of discretion standard. I think under either standard, the city would prevail, but again, I just thought we'd note that there's a difference in the standards, at least in some of the case law. But with regards to the merits of that argument, it's interesting that the court noted that in its entry awarding the fees that the case had already been refiled. The court had already been made aware of that, we've already taken possession and gone ahead and taken trees down, but that wasn't in the entry. But the fact that it was refiled, we think flies in the face of the interpretation of, or what that statute was all about. And we've got no problem, I mean, I agree with the fact that if there's an appropriation of proceedings and it's abandoned.
Counsel, I just have a question for you.
Sure.
Is the second appropriation proceeding in evidence in the record?
I'm sorry, what was
Is
that?
it in the record?
Well, the refiling and the case number are in the record.
Okay. And did you provide the second filing for the record? It's
For this record,
yeah.
I don't believe so. But again, I know that it was noted in a lot of the motions going back and forth regarding the petition. And in fact, I think the petition was reassigned over to Judge Rothgary at the time.
And was there evidence in the record, is there anything in the record to show that the work on the property had commenced?
An affidavit that we had filed from our building director. While the court was considering, or after it had made a rule, we asked the court to reconsider. We included the affidavit from our building director saying that trees had already been removed. But that...
In the record for this appeal?
Yes, that's in the motions.
All right.
I just want to clarify,
Mhm.
obviously we'll look at all that,
Yeah.
but, so you filed a motion for reconsideration, and that's the only time the affidavit's brought to the court's attention?
Correct. We had brought it to the attention, but without the affidavit. And we weren't sure if maybe that was the reason that the attorney's fees were granted. But that does bring up the issue of possession, which I think this analysis is two-pronged. One, did the city ever take possession? And in and of itself, the fact that we did a quick take under the statute and deposited the money, there's no case law on that, but it does, I believe, provide a possessory interest to the city. We've already given up the money, it's there for the taking, it's for a certain project, it's under statute that we can do that, and it gives us the right to immediate possession. So I think that that is one way to look at it. And another way to look at it is we took possession. We literally went on the land, cut the trees down, removed, things that we needed to do, started working on the project. And all of this, again, was done before the court made its ruling, and we believe the court was notified of this through the motions that we filed before it made its ruling, and after with the affidavit. We think that there's a couple cases of note talking about the abandonment of proceedings, because the court ruled, in essence, if you file a petition and dismiss it, voluntarily dismiss it, it's automatic that the statute applies. We don't think that's what the statute says. We think that the statute is clear in that it says appropriation proceedings, and a complete abandonment that has been defined by the House Supreme Court as having no further interest in it. The fact that we refiled it, and that the court was aware of that, shows that there was no abandonment. So we think that the court was wrong in its interpretation of the statute, or in its interpretation that voluntarily dismissing an appropriations case automatically means attorney's fees. It doesn't say that, and I don't think that's the intent of the statute. I believe the intent is if you actually do voluntarily abandon the proceedings, then the person who had to pay the money to defend up to that point should be reimbursed for that. But in this case, again, that's not the case. We can't seem to find any case law, I don't think, either party directly on point with this. So I'm not sure if this is a case of first impression, but it's nothing that I was able to find, and nothing that we saw in any of the briefs where the case had actually been refiled, and the city had already taken possession of the property, and then attorney's fees were awarded for the prior filing for the first petition. Again, we believe that the trial court misinterpreted that and misapplied the statute to the facts of the case. And I think the important thing is, when you're asking about whether or not the affidavit was filed before, or when it was filed, I think more important is the fact that the court was aware that it was refiled, which again, just to me, is completely contrary to what the intent of the statute is. The court noted in its entry, the case has been refiled, however, voluntarily dismissing it subjects you to attorney's fees. Nowhere in the statute is that said, and in fact, I think that's some kind of punishing a party for refiling a case, which I've never seen before. And we just think that the court erred and or abused its discretion in its interpretation and application to this case.
It sounds like the interpretation was that they abandoned those first proceedings, because when you dismiss and you're saying the case is over and there's no more jurisdiction, that those proceedings are over and you've abandoned the initial proceedings.
Well, the initial, again, the word abandonment is a complete relinquishment of rights, at least according to that one's House Supreme Court case that we had, and we didn't. We refiled the case. And the court knew that prior to making its decision.
The appellant here shouldn't get attorney's fees for the first case when the city's ducks weren't in a row in the filing and there wasn't actually a...
Well, we don't think, no, it shouldn't, because it wasn't the fact that we had to dismiss it to get it refiled. We already cured that defect with the resolution by amending the complaint and refiling it with an appropriate petition. We dismissed it because we believed that there was going to be an interlocutory appeal on the decision of the court to accept that and go forward and further delay the process.
But that was the decision you made.
That was a decision we made. Again, based upon what we had seen, how this case was evolving.
You were right about it, 2 minutes.
Oh,
Well
perfect.
done.
Well, thank you.
Good morning. May it please the court, opposing counsel, I'm Lorain App.No, counsel on behalf of respondent appellee Sharon Zilka today. Ms. Zilka is an elderly widow, resides in Avon. We're here today because without proper authorization, City of North Ridgeville attempted to appropriate her property. Ms. Zilka hired a lawyer, and after 3 separate filings with trial court notifying the City of North Ridgeville that its appropriation petition was deficient, a motion for judgment on the pleadings, which also sought attorney's fees, a motion in opposition to their request for leave to amend the complaint, which sought attorney's fees, and a motion to dismiss the amended petition, which also sought attorney's fees. Only after that did the city concede that it lacked the statutory authority to take her land by eminent domain and ultimately voluntarily choose to dismiss its case. In such circumstances, the Ohio Revised Code provides that a homeowner like Ms. Zilka, forced to retain legal counsel and defend her property against an appropriation proceeding that she never asked for, is entitled to recover attorney's fees and costs. That's what this appeal is about. Ms. Zilka owns a tract, it's about 4.5 acres, it's at the corner of Stony Ridge and Mills Road in Avon. The city wants to take about 2/3 of that frontage and put a roundabout in at the intersection, which is going to destroy the value of Ms. Zilka's property and destroy her ability to parcel it off and sell it as residential lots. While a municipality in certain circumstances can appropriate property, the Ohio Supreme Court has interpreted Section 19, Article 1 of the Ohio Constitution as requiring that a property owner be compensated for every injury that comes from that act of appropriation.
Counsel, let me ask you a question. If the appropriation had gone forward when it was initially filed, it was all okay, the resolution was there and so forth. Obviously, she could have contested it, and it could have gone to a jury trial as to the amount that she was owed, and all those issues could have been raised that you're talking about now. If she, still wasn't happy with it, obviously she'd be able to appeal. But I guess my question is, what does the statute say about who pays, if there's no abandonment, if there's a full procedure, what does the statute say about cost and attorney's fees for the defendant that the person is having their land taken away?
Sure, so that's a great question, Your Honor. And the statute says that in the case where the verdict exceeds the good faith offer by the appropriating agency by, I believe, it has to be more than 125%, I think, don't quote me, that we would be in a position to seek attorney's fees and costs there. So that would be, had this appropriation action not been abandoned, and had it gone to verdict, and had we done considerably better than what was offered pre-suit, we would have an opportunity to recover fees and costs under the statute. Does that answer the question?
Yes, it does. Thank you. I appreciate that.
Now, before a city, like City of North Ridgeville, has the opportunity to appropriate property, it has to be sure to satisfy the statutory prerequisites. Among those is the prerequisite set forth in ORC 163.05B1 and 719.04, which requires a resolution from a public agency before an appropriation action can be filed. And I want to speak to some of the discussion that I just heard, because I think there's some confusion as to what resolutions were actually passed by the City of North Ridgeville at the time of filing. They had not passed any resolution to appropriate Ms. Zilka's property. They had passed a resolution to carry out a project, a roadway project, that included proposed roundabouts and other features. There was not, at the time of filing, a resolution to appropriate Ms. Zilka's property.
But that resolution was attached to the complaint.
The project resolution? Yes, it was, but it doesn't satisfy the statutory requirement that the appropriating municipality have a resolution to appropriate that piece of property for which it's filing a petition for appropriation.
I understand your position.
So I want to make sure I understand.
Sure.
So at no point did the City of North Ridgeville actually file an appropriation for a resolution of necessity to appropriate?
Not Ms. Zilka's property, Your Honor.
Not her property.
That's correct.
Did they pass other resolutions for the other property owners?
That I'm not aware of. They did not in this case. Now, post hoc, they tried to, so I'm not
What
going
do
to
you
say.
mean post hoc? What do you mean after?
After they filed this petition and we saw a judgment on the pleadings and dismissal.
After the first filing?
Yes, ma'am. Yes, Your Honor. There's no dispute that the petition didn't attach a resolution authorizing the taking of Ms. Zilka's property. Now, despite the fact that the appropriation petition was deficient and improper, Ms. Zilka was forced to retain counsel to defend the action. As I said, we first filed a motion for judgment on the pleadings and for attorney's fees, pointing out that the appropriate resolution wasn't attached. Instead of dismissing, the city sought leave to amend. After they filed an amended petition, after we opposed the motion for leave to amend, arguing that it wasn't going to be a post hoc resolution, it wasn't going to be sufficient to establish jurisdiction, and sought fees, the city was granted leave to amend. They amended, and as anticipated, attached a post hoc resolution. So then we sought
And
dismissal.
that resolution was a resolution to appropriate for
Ms.
property.
Zilka's property, yes, Your Honor. Once that amended petition came through, we sought leave to dismiss on jurisdictional grounds, and in response, faced with the reality that it was going to be successful, the city voluntarily dismissed their own petition. Thereafter, we renewed the motion for attorney's fees that we filed 3 times previously, which was granted by the trial court. The appeal presents 2 assignments of error. The first is jurisdictional, that there was a lack of jurisdiction to award attorney's fees. And the second is whether the decision to determine that the city abandoned the appropriation and therefore that Ms. Zilka was subsequently entitled to fees was erroneous. Now, there's a couple of things that the parties agree on in this case. One is that the value of the attorney's fees in question is $15,220. That's a figure that the parties had agreed on. The second is that the standard review on the jurisdictional question is de novo. And the third is, I thought, that the standard of review on the question of whether or not the trial court's conclusion that they abandoned proceedings was an abuse of discretion. I understand that maybe there's some dispute over that, but I would rely on City of Lorain versus McKeel from this court, finding that the decision as to whether or not an appropriate agency abandoned appropriation proceedings is reviewed for an abuse of discretion standard, which is among the toughest appellate standards to satisfy. You have to show that the trial court was unreasonable, unconscionable, arbitrary. But turning first to the jurisdictional argument, both sides rely on State Ex Rel. Hummel versus Sadler, which stands for the proposition that because a claim for attorney's fees is collateral to the main action, a court retains jurisdiction to hear it even after dismissal. And I think there's a quote from Hummel that I think is important, and I want to point out that Hummel's a 2002 decision from the Ohio Supreme Court, which I think will be important in a second. But the quote is this, quote, "When a case is dismissed, the trial court is not divested of jurisdiction to hear a claim for attorney's fees, simply because the basis for the claim is a statute or rule different from Civil Rule 11 or Revised Code 2323.51. I say that's important because in the appellant's brief, they rely on a case from the 9th District, Baker versus USS Steele, which on its face appears to reach a contrary conclusion that collateral jurisdiction on attorney's fees only exists under Civil Rule 11 or Revised Code Chapter 2023, kind of the statutory corollary. I don't think that that's Baker's holding, but even if it were, Baker was decided in 2000, and so that decision would be tacitly overruled by the Supreme Court's decision in Hummel 2 years later, saying specifically that collateral jurisdiction is not limited to Civil Rule 11 or Revised Code Chapter 2023 arguments. Here, the claim for attorney's fees is made pursuant to statute 163.21, and pursuant to Hummel, the trial court retained jurisdiction to hear that collateral issue even after the city's voluntary dismissal. In fact, and I think it was touched on by the panel during the appellant's argument, this very city filed its own motions after its notice of dismissal, a motion for reconsideration and a motion for final appeal order language. So it's disingenuous to my mind for the city to file its own motions with the trial court post-voluntary dismissal and then allege that Ms. Zilka is entitled to do the same thing. Also significant, I think I've touched on it, is the fact that 3 times prior to that voluntary dismissal, we thought we'd sought fees because we knew that the petition was deficient on the day it came in. Now, recognizing that the court retained jurisdiction, I would turn to the argument as to whether the determination that the proceedings were abandoned was appropriate and therefore entitled us to attorney's fees under the statute. Trial court determined that this, of course, was an abandonment under 163.21 and didn't abuse its discretion in making that determination after the city voluntarily dismissed its own appropriation action and took back the money that it placed on deposit with the clerk of courts to allegedly exercise its quick take authority. And I'll come to that point in a minute because I think it's important. But I want to start with the fact that under 163.21, where a determination is made that an appropriating agency has abandoned appropriation proceedings, the court shall award attorney's fees and expenses. It's mandatory under the statute. And here that sum is agreed to by the parties. That's the $15,220. But instead of disputing that, we've got this notion that that they had allegedly taken possession prior to their voluntary dismissal, or that because they refiled, this doesn't constitute an abandonment. I will tell you that the city did not and could not have taken possession of the property prior to the notice of voluntary dismissal. For one reason, the property is still owned by Ms. Zilka, title hasn't been transferred. But I think more important than that is some of the quick take argument that you heard earlier this morning. The city's alleged that they exercise quick take authority to get to the property. Now, quick take authority requires a couple of things. One of those things is a declaration of intent to exercise quick take authority over the very property in question. Now that comes from 163.06B. We know that that declaration didn't exist because there was never a resolution to appropriate the property in the first place. So the city couldn't have satisfied that statutory requirement to exercise quick take authority. Number two, exercising quick take authority requires the funds be placed on deposit, but as I said earlier, upon their voluntary dismissal of this action, the city took the money back. So the money didn't flow through to Ms. Zilka. It wasn't used to apply towards the attorney's fees she's incurred in defending this action. The city took that money back. We've heard a little bit about this notion that they were out there clearing trees, but I would ask the panel to take a close look at that because if you look at the reply brief filed before this court, there is an argument that they were cutting down trees, and the argument is that that happened in May of 2023. That date's important because that's 2 months after they had already voluntarily dismissed the appropriation action. So the argument before you is that they exercised quick take authority and therefore couldn't have abandoned the proceedings, but they didn't actually take possession of the property by coming on it to cut down trees until 2 months after they abandoned their appropriation action. And coincidentally, that's an act that happened after we filed the renewed motion for attorney's fees, arguing that they abandoned this appropriation. The timing is important there. That had not occurred at the time they dismissed their appropriation proceedings. And in fact, they didn't refile this action for 6 weeks. Now, I will tell you that I think the filing of the subsequent action has no impact on the analysis of whether this proceeding was abandoned. And I think that the court touched on it earlier. This case number was abandoned completely. They were divested of any interest in that case. I understand that they filed a new petition 6 weeks later with a different case number, and that's going to work its way through the court system. This proceeding was unquestionably abandoned. If you look at there's a Third Circuit decision, City of Dublin versus Washansky. In there, the court concluded, and I'll quote, Ohio courts have generally found that where an agency voluntarily dismisses its appropriation action, it's abandoned proceedings for purposes of RC 163.21. Washansky cites the Ohio Edison versus Franklin paper case. That's an Ohio Supreme Court decision from the 80s. Besides that case, there's State versus Sellers, Department of Natural Resources versus Sellers from 1968, so more than 50 years ago, where the court specifically found that a dismissal without prejudice, like the dismissal here, was an abandonment for purposes of 163.21. The trial court in our case didn't abuse its discretion by reaching the very same conclusion. This is precisely why the statute exists. A homeowner who doesn't want her property taken has to come in and defend an action and incur fees and costs as a result. The city then turns around and says, on second thought, I don't want it. Now, the time and value she's put into that case is rendered worthless. She's entitled to be compensated for it. 163.21 is a remedial law to be liberally construed. That's Ray versus Alvey Holdings' first district decision. Here, the statute should be liberally construed to protect Ms. Zilka's right to recover attorney's fees and costs for the city of North Ridgeville without appropriate municipal resolution, attempted to appropriate her property, force her to file at least 3 separate submissions with the trial court pointing out this deficiency before ultimately voluntarily dismissing its own petition. Accordingly, appellant's appeal should be denied and the decision of the trial court affirmed. Thank you.
Counsel, I just want to clarify the cases that you cited in regard to constituting an abandonment of voluntary dismissal. Those were cases, though, where there was no evidence that it was actually ever appropriated, that they did not take possession, correct?
I would have to review that, Your Honor.
Thank you.
Thank you.
Okay, thank you. Judge Carr, I think you're correct that those cases that were cited to, there was never any refiling, which happened in this case, and which was actually recognized by the court before awarding the attorney's fees. But a couple points that I did want to make out. We didn't voluntarily dismiss the case because the arguments that were being raised now about not having subject matter jurisdiction, once the initial petition was filed without it, that the court loses it, that was cured when it was amended. When the court granted leave to amend it and we included the petition, it was cured and we were ready to go forward. No matter how many times they want to say it, the reason we did it was because we believed that this was going to lead to additional tactical maneuvers, legal maneuvers by the appellee to delay the project. So any defect was cured with the amended complaint. Also, in the case of Hummel that they cited to, and I asked this court to look at that, I'm sure it's going to look at it carefully. In that case, this court specifically retained jurisdiction to consider fees, and it considered fees as a sanction, collateral to the proceeding, which again is an exception to the general rule. Regarding the quick take argument, in both petitions, the declaration to intent was take was in the petition itself. I don't think that there's any law that says you can't have the declaration of to take it immediately separately, that it needs a separate filing, but they were in both petitions actually. And we didn't take the money back, the court returned it, and we deposited again the same amount. It's the exact same petition that was refiled. By the court's interpretation of it, again, I think that the intent of the statute is to, again, address costs that are associated with appropriation proceedings that have been abandoned. I mean, it's pretty clear. In this case, everybody, I hope, is in agreement that this appropriation proceedings were not abandoned. We refiled and we're going forward with the project.
Going over time, did you have a
I
question?
just have one quick question,
Sure.
quickly, and that is in regard to the quick take procedure that you ultimately utilized. That's under a different statute.
Well, it's under a different, yeah, it's the 163, 163, I think it's .21, or maybe
That's okay.
.08. It's in that chapter. Yes. So with that being said,
I do want to clarify, the state extra Hummel v. Sadler case, you're saying, if I understand how you distinguish that, is when a case, the language is, of course, when a case is dismissed, the trial court is not divested of jurisdiction to hear a claim for attorney fees simply because the basis for a claim is a statute or rule different from Civil Rule 11 or RC 23-2351. You're saying that the context of that has to be a sanction.
yes. Well, or something collateral to the proceeding.
And you're saying this is not a collateral proceeding?
Correct.
Thank you.
Okay.
Thank you both for your presentations. The court will take the matter under advisement, issue a decision in due course. The clerk of courts will mail a copy of the decision to you on the day it's released, and it will also be posted on the Ohio Supreme Court website. Thank you both very much.
Thank you.